All right, ladies and gentlemen, this is week number 5 of CRJ 227. That's right, we're over the hump, past the halfway point, and we're going to talk about search warrants this week. And again, this is something, there's overlap in everything. This is something that if you were in 230, you've spent a lot of time with. But I need you to read the summary document I provided in the assignment form before you listen to this podcast. So if you haven't done that, go and do that. This will make more sense. And then you're going to present in your own words a recent news story or case with a working link or a valid citation that discusses specifically an issue related to the police obtaining a search warrant. That's obtaining a search warrant. Not using a search warrant, not something that focuses on using the search warrant, although that's likely to be covered in the case, but I want your focus to be on issues related to how they obtain the search warrant. Again, no high-profile cases, nothing that's been in the national news. Keep it more local, think simple, the type of low-profile, not a murder or heinous crime cases that you're going to probably deal with, we read about in the local newspaper, you're going to deal with on a more consistent basis. And, you know, these things happen all the time. It could be related to drugs. It could be related to possession of stolen goods, weapons. While traveling through Peoria the other day, I saw a conglomeration of city, state, and county officers meeting up at a place to then get prepared and get set in their tactical gear and go, I assume, exercise a search warrant. So, you know, these are, sometimes they're high profile, but most of the time, you know, they're in the realm of the things that you'll deal with more often than not. And then present those things in your own words. As you review, what are some of the things you'll plan to do as you write your applications for search warrants? If you don't know what I'm talking about there, you didn't do the reading. If you do know what I'm talking about, you did the reading, and the cases will make more sense. But how are you going to avoid How will you avoid some of the issues that you're going to read about this week? On deadly force, there's been, unfortunately, additional incidents since we began this class. So find some of those instances, summarize the facts and circumstances, and then applying the knowledge you've earned up till now in the 4 weeks, the month that we've been in class. Describe the procedural concerns with the stop, the pursuit, the actions that led to the culmination or the use of deadly force with legal terms. Legal terms you now know and you can apply to those circumstances. No feelings, no opinions until you apply the law. 4 weeks ago, you may have felt emotional and properly so. But for our purposes, now you know what the law expects. So what should have happened? What didn't happen? What could happen? What should happen in the future? So before you get to feelings, think about those things in the law and make sure your opinion is based in law, because you're more than competent and well equipped to do that at this point. Now, getting back to search warrants. Police seek arrest warrants and search warrants, and both arrest warrants or search warrants have 3 essential components. First, the warrant has to be issued by a neutral and detached magistrate. In Illinois, it's a circuit court judge or an associate circuit court judge who issues these warrants. Second, the police must show probable cause. And then finally, it must conform to the Fourth Amendment's particularity requirement. Now we're going to focus on search warrants this week because search warrants are challenged more often than arrest warrants. So using the Peoria Police as an example, a Peoria police officer seeking a search warrant has to obtain that search warrant from a neutral and detached magistrate, one of the circuit or associate circuit judges presiding at Peoria County Courthouse. Usually there's a primary judge identified in a backup, and the police know who those people are and who to contact and how to contact them. In order to obtain a search warrant from that judge, two things must be shown. Number one, probable cause. Showing probable cause for a search warrant is a two-part process. First, the officer applying for the search warrant must show probable cause that the items seek to be seized are connected with criminal activity. So you have to outline facts that whatever it is you're saying you're going into the structure to search for is connected to criminal activity and the facts related to that, how you line that up. Second, the officer must show probable cause that the items to be searched for and then ultimately seized are in the location to be searched. So it's not just a matter of saying, we think. How do you get those items to this place you're going to ask the judge to allow you to search? It can't just be, it probably is. It needs to be based on facts. Someone saw the items there. A witness told you that the suspect took those items there. The suspect was followed to that location or seen going in with the items. Okay, more than just conjecture. And then the other element, particularity. The particularity requirement for a search warrant has two elements. First, the warrant must specify the place to be searched. Next, the warrant must specify the items to be searched. The reason for this particularity requirement stems from the framers of the Constitution's concerns with so-called general warrants that were issued by the King of England. These general warrants were used for political purposes. They weren't particular. These warrants permitted limitless searches for evidence of treason. It should be noted, mistakes occur as to the place to be searched. For instance, an incorrect address for the property listed on the warrant occasionally leads to the wrong home or structure being searched. Now that shouldn't happen if you're careful. If you have multiple sets of eyes familiar with the place you want to go, doing their due diligence on the address, eyeballing it, making sure they have it correct, and then going to the proper structure. Now, if you get the warrant issued and the street address is 1804 North Delaware Street, and that's what it says on the warrant, but you really wanted to go to 1806, guess what? You got to go back and see the judge and say, we screwed up. We really want to go to 1806. It was a misnomer. It was a misidentified or mistyped or listed address. Everything else, all the same. We have probable cause and particularity, but we just were a little off on the address. When it can go south is when that mistake leads to the wrong structure being searched. And there are plenty of examples. The one that comes to mind for me is a local one of they go out to serve the warrant and they hit the door with the ram bust the door off the hinges, off the frame, and here's this little old lady sitting there, watching TV, minding her own business, and fortunately she didn't have a heart attack and die because the police were at the wrong house. They wanted to be next door. It was embarrassing. They had to replace the door, end up in the paper. And what do you think the individual next door did, who was the real focus of who they wanted to search? I'll bet they got rid of, or tried to get rid of, whatever the police were in search of. So little things, particularity. Search warrants are challenged far more often than arrest warrants, as I said earlier, primarily because the potential for shortcomings in the affidavit with probable cause. It's especially true with narcotic search warrants, as the evidence is often easy to move or dispose of. As a result, search warrants are rejected and the evidence obtained thrown out for a variety of reasons, limited solely to the imagination and gumption of a defense attorney. The effort and diligence of the police officer who sought the search warrant and the carefulness of the judge who reviewed the application for the then issued search warrant will be scrutinized. Examples you may see in cases or news items that will show up this week will be things such as failure to be specific as to the time frame narcotics were on the premises that was sought to be searched, or failure to connect the evidence sought to the property to be searched, or an affidavit that's riddled with conjecture or generalization. Habitual users of drugs keep drugs and paraphernalia in their home. That's a generalization. It's much different than suspect John Smith was seen going into the home carrying, more specifics. Or too much reliance on opinions based on an officer's training and experience. Those are the key words. Those are the key words that will come up in testimony. Those are key words that get often overused. It's great that you have the training and experience, but what are the facts based on that training and experience that lead you to believe the contraband is in this structure? Now, typically, if they think long and hard about it and they've worked the case, those facts are there, and it's a matter of drafting those facts into something that flows after your training and experience. Based on my training and experience, I saw this, and facts, observations. In other words, tell the judge what you know, not what you feel in seeking a search warrant. Which leads us to the final part of this week's assignment and our focus on deadly force. I'm assuming that you look at the news on a regular basis, and if you don't, I'm not going to say you probably should, but you probably should, especially as it relates to developments in policing or the law. Now, I know police officers, and I know myself. I have not been following the local news of late, and I go in these cycles. I have a young officer who I happen to have over for dinner a week or so ago, and he flat out said, "I do not watch the news." Well, for our purposes, you're not there yet, and I'm going to ask you to watch the news. And when you watch the news too regularly, and especially, as I said earlier, in the past month that we've been in class, there have been incidents involving police use of force. what I said earlier was that I want you to focus on what you know about the law related to the facts available on those incidents, not focus on what you feel. Now, what you feel is important, and if something based on the facts and the law is clearly inappropriate and should not have happened, well, then you feel how you feel, and you should feel that way. That's how we know not to do those things, to change behaviors, to change perceptions, to change how we address things. But my point here is, you now know enough about the law, and when you look at those circumstances through the law as you know it, you don't even have to feel wrong about it. You know it's wrong because the law tells you it's wrong. So I want you to begin offering your opinion based in law and not based on your feelings about the law or anything else. While we feel, and we should enforce the law with compassion wherever possible, at the end of the day, determining the reasonableness of, the intent of any action requires all of us. And whether we're talking about judging the police, judging a suspect, judging a defendant, judging a prosecutor, judging a judge, it all needs to be done on the facts as applied to the law. So change up your mindset a little bit. And, you strengthen your argument. You can believe. I've shared, where I've tried to take this course and the reasons I tried to take it there in the first week. And you can believe that I have had multiple conversations with many people from all over the spectrum. People that were pro-police, people who were defund the police, people that, are just all over the spectrum. From a lot of different angles. When I break down any of those cases, I try to break them down by looking at the circumstances and what I know the procedural law to be, what I know the Constitution to guarantee people, and what I know that I of the Constitution would say about how those circumstances transpired. And we can look at something and know it's wrong, but I like to say, something more than feeling. That was wrong because the law does not allow that to happen. And once we get to there, and once we get to the point where we can, get people to recognize it's just plain wrong. It should not happen. It's not legal. Then we can start going in a whole other direction, hopefully. So I want you to kind of flip that a little bit and start using the knowledge you've gained over the last 4 weeks. And guess what? You've gained a lot of knowledge. You may not realize it, but when you do that exactly this week, you will see that you have. All right, week 5. Stay safe. If you need me, you know where to find me. I can now meet you at Poplar Hall. We can travel about, but be safe on that too, okay? I'm seeing this stuff about this variant, and man, I got a kid living in Florida, and he wouldn't get the vaccine. I'm like, buddy, go get it. If you haven't done that, think hard about it. I still the jury's out in my perspective about whether I'm fully protected and all that, but doesn't make any sense not to. All right, stay well.